So now we will have from the board read questions that have been previously submitted prior to this meeting by the public. We're going to get through as many as possible within 30 minutes. So Andrew, I will pick them at random, tell you the number, and you can read the question.
Thank you.
Starting with number 2.
Thank you, Chair Lawson. I'll go ahead and begin the 30-minute timeline. Question 2 has 7 parts. So, Chair Martinez, I'll begin with the first part. What does interpretation and...
Let me just pause. It was a clever of the submitter question.
There's more than 30 questions in that question.
7 parts. Andrew, maybe next time that's 7 questions, but go ahead for now. Thank you.
The first part reads, what does interpretation and or translation access look like for anyone in your custody?
Thank you for the question. The San Diego Sheriff's Office offers translation services to everyone in our custody to ensure that they understand their rights while in our custody. All ICE-related forms are available on 7 identified languages: English, Spanish, Chinese, Tagalog, Vietnamese, Korean, and Arabic.
Second part is, what systems do you rely on to determine someone's identity and personal identifying information, such as county of origin, particularly for those who can't communicate in English?
Well, obviously, if they have valid ID on the person with their book, or if they provided identification to an arresting officer, we will have that. The demographic information is self-reported by the incarcerated person during the booking interview, and if the individual is unable to speak English, translation services are provided.
Third part, what types of community member data is shared with ICE, DHS, CBP, and through which mechanisms or systems is that information transmitted?
So for individuals that have been determined to have a qualifying conviction and have an approved J340 form, the San Diego Sheriff's Office staff provides a notification to ICE via telephone, which provides ICE the release date. The San Diego Sheriff's Office provides general information for the individuals in custody via the Who's in Jail app, and that just basically gives the date of birth, sex, race, height, weight.
Fourth part, is any personal data being shared before a transfer has been made over to federal officials?
During the course of a detention, arrest, or investigation or interrogation, the Sheriff's Office personnel are prohibited from a number of things, and I'll list them: inquiring into a person's immigration status, detaining an individual on the basis of an immigration hold request, providing information regarding an individual's release date, or responding to a request for notification of release dates to the immigration authorities, or other information unless that information is available to the public or is in response to a notification request from immigration authorities in accordance with California Government Code Section 7282.5, where prohibited from providing personal information as defined. Providing personal information is defined in California Civil Code Section 1798.3 about an individual, including but not limited to individual's home address or work address or other identifying information, unless that information is available to the public, making or participating in arrest based on a civil immigration warrant, assisting immigration authorities in activities described in Section 1357A3 or Title 8 of the U.S. Government Code, and that is it.
Thank you. Part 5, what access and privileges are granted to ICE or other federal agents on county property, including non-public areas?
Outside law enforcement agencies do not have free access to any sheriff's facilities or jails. They're required to check in via the primary entrance point and follow professional visitor guidelines.
Sixth part, how is the determination made that a person is a non-citizen, and what protections and accountability measures exist to prevent wrongful detention or transfer, including of U.S. citizens?
So the Sheriff's Office does not have the capability to access or look up an individual's immigration status. We do not have access to any databases that contain information about an individual's current immigration status. It's in accordance with our operational protocols and legal requirements, and additionally, our jail population management unit is prohibited by law from communicating with immigration officials about an individual's immigration status. Our unit strictly adheres to these legal constraints to ensure compliance with all relevant regulations. Our operations rely heavily on the inquiries made by immigration officials. When immigration officials reach out to us, it's typically to notify us that they, ICE, are questioning an individual's immigration status. This usually implies that the individual may not be legally present in the country, and the officials are seeking to determine if an incarcerated person qualifies under the SB 54 guidelines.
And the last part of this question, the Values Act statistical report includes information of at least 5 individuals who reported being U.S. citizens. What are the circumstances in which a U.S. citizen would be transferred to federal officials?
Citizen status is self-reported information provided by the incarcerated person during the booking process. The sheriff's office does not have the ability to investigate their immigration status, and it's against the law for us to do so.
Andrew's telling me to pick her number. 15.
Question 15 has 20 parts. We'll start with the first one.
She's in there.
Since February 27, 2026, how many individuals has the Sheriff's Department transferred to ICE custody?
This information will be available in August of 2026, followed by quarterly reports.
Of those transfers, since February 27, 2026, how many were supported by a judicial warrant as required under San Diego's clear ordinance?
This information will be available in August 2026, followed by quarterly reports.
Does the department intend to fully comply with the San Diego County clear ordinance? If yes, what specific policy changes, training, accountability measures have been implemented? If no, what is the legal basis for declining compliance with state and local law?
There's a little bit of two-part. We did undergo the Clear Act training that was provided to our agency. We have submitted facilities for the signage under the ordinance. But as an independent elected official, I set the policy for the sheriff's office, and California law prohibits the board of supervisors from interfering with my independent, constitutionally and statutorily designated investigative function as a sheriff. And it's clear that I have the sole and exclusive authority to operate the county jails. State allows the sheriff's office to share release dates for individuals who are in the sheriff's custody, only if they have qualifying convictions for specific serious violent or sex crimes. SB 54 gives the authority for law enforcement to cooperate with immigration authorities as prescribed, and many are referencing that because the board policy is in place that I can follow it. However, unlike the local police department where the elected city council can set the policy for the chief of police that the council appoints, an elected sheriff answers to the voters and sets the policy for the sheriff's office. The provision referencing policy doesn't impact the sheriff, however, applies to the local police departments where their city governments establish their policy limits and 54 provisions.
Part 4, for all individuals transferred to ICE in 2025, what specific statutory exceptions under SB 54 were used to justify each transfer where a judicial warrant was not presented?
So that goes to the different crime charges, 11352A, Health and Safety Code, 191.5.5B, Penal Code, 207A, Penal Code, 211, Penal Code, 236, 237 of the Penal Code, 236, 237A, Penal Code, 243.9A of the Penal Code, 245A4 of the Penal Code, 245A4 of the Penal Code, 1724, 273A of the Penal Code, 2800.2A of the Vehicle Code, 288A of the Penal Code, 4573.6 of the Penal Code, 459 PC, 470D of the Penal Code, 47.2 of the Penal Code, 212.5B of the Penal Code, 530.5C1 of the Penal Code, and 69 of the Penal Code.
In cases where individuals were transferred despite convictions older than 15 years, including those from 1995, 1996, 2005, and 2008, what legal rationale allowed those transfers under SB 54?
So section 1, the individual has been convicted of a serious or violent crime identified in subdivision C of section 1192.71 of or subdivision C of section 667.52 of the Penal Code. Section 2, the individual has been convicted of a felony punishable by imprisonment in state prison. Section 4, the individual is a current registrant on the California Sex and Arson Registry. Section 5, the individual has been convicted of a federal crime that meets the definition of an aggravated felony as set forth in subparagraphs A to B, inclusive of paragraph 43 of subsection A of section 101 of the Federal Immigration and Nationality Act, 8 U.S.C. section 101, section 66. The individual is identified by the U.S. Department of Homeland Security's Immigration and Customs Enforcement as the subject of an outstanding federal felony warrant.
Part 6, how does the Sheriff's Office ensure a consistent and legally accurate interpretation of SB 54 eligibility criteria?
We stay up to date with current California legislative bills that are signed into law that impact SB 54 provisions. We do training bulletins and we work with the Sheriff's legal team for interpretations.
Through what mechanisms is information shared between the Sheriff's Office with federal officials or agents, for example, databases, direct communication, joint task forces?
So there's a telephone call for notification of those individuals that are qualified for SB 54. Federal law enforcement officers have San Diego Law, which is a local criminal history system.
Part 8, are federal immigration agents permitted to enter sheriff's non-public areas? For example, sally ports, intake areas, parking facilities. If so, under what policies or agreements?
Outside law enforcement agencies do not have free access to any sheriff's facility or jail. They are required to check in via the primary entrance point and follow professional visitor guidelines.
What local or regional databases or communication systems are used to facilitate information sharing with federal immigration authorities?
Federal law enforcement officers have SD Log access, which is a local criminal history system.
Part 10, has any federal agency asked the Sheriff's Office to conduct a traffic stop, a whisper stop, or any other stop of a civilian? How many of these stops have resulted in an immigration-related detention?
The Sheriff's Office works with law enforcement partners to disrupt drug trafficking and criminal activities that violate state law but not immigration law.
Part 11, does the Sheriff's Office have a policy to address requests from federal agencies to assist with a stop, assist with crowd control, or a call for cover? Can you make any policies public?
There isn't a policy that addresses requests from federal agencies. We treat requests for cover calls the same regardless of what law enforcement agency calls for that help.
Part 12, what local resources, including staff time, facilities, transportation, or equipment, are used by the Sheriff's Office to support federal immigration enforcement activities?
A staff study has not been performed to capture this process, and staffing has not been increased to accommodate any fluctuations in request forms.
How does the Sheriff's Office track and report the use of these public resources? How much is the value in dollars of these public resources?
Staff study has not been performed, and we have not increased our staff to accommodate IT process.
Part 14, what safeguards exist to prevent the wrongful detention, notification, or transfer of U.S. citizens to ICE by the Sheriff's Office?
We do not ask anyone their immigration status, and it's important to note that saying the Sheriff's Office does not have the capability to access or look up any individual's immigration status. We do not have access to any databases that contain information about an individual's current immigration status, and this is in accordance with our operational protocols and legal requirements. Additionally, our jail population management unit is prohibited by law from communicating with immigration officials about an individual's immigration status, and our unit strictly adheres to these legal constraints to ensure compliance with all relevant regulations. Our operations rely heavily on the inquiries made by immigration officials, and when immigration officials reach out to us, it is typically to notify us that they are questioning an individual's immigration status. This usually implies an individual may not be legally present in the country, and the officials are seeking to determine if an incarcerated person qualifies under SB 54.
Part 15, how does the Sheriff's Office respond to documented cases in which individuals reported being U.S. born, but were still transferred or referred to ICE? What oversight, auditing, or complaint mechanisms are in place to detect and correct these errors?
The same answer as previous. We just don't do it.
Part 16, how is demographic data, including ethnicities such as Native American identity, collected and verified by the Sheriff's Office in ICE transfer reports?
This information is self-reported and collected into the jail information management system. That's what I got.
Second, or 17, answered this, but are individuals self-identifying, or is this information assigned by staff or derived from other records?
That's something.
Part 18, what internal policies, legal guidance, or supervisory approvals are required by the Sheriff's Office before honoring ICE requests?
Our process is governed by SB 54, the California Buildings Act.
Have these policies changed in the last year? If yes, what are the changes?
There will be no changes to our policies.
The last part of this question, are you concerned that continued ICE notifications and transfers by your office expose individuals to prolonged or mandatory detention and deportation under current federal policy, including the denial of bond and serious concerns about detention conditions that have led to a historic number of deaths? Given these risks, are you willing to halt transfers of community members to ICE custody?
It is concerning the things that we see in the news. There's no ignoring what we've seen across the country. However, I do think it's still in the best interest of public safety that we continue forward.
Number 20.
Number 20 reads, is the probation department complying with policy L2? Does the probation department intend to comply with the clear ordinance?
Probation is not American as a prison.
Oh, you are. So probation department does comply with board policy L2 and under the California Youth Values Act. They intend to and do comply with all laws, policies, and ordinances, including the clear ordinance.
Only one part. $11.
Question 11 reads, will you commit to stopping ICE access to county facilities?
No. The short answer.
Number 4.
This question has 6 parts. First part, why does the San Diego Sheriff's Office refuse to honor board policy L2?
Since becoming the sheriff, I've been committed to balancing the requirements of state law and the sheriff's office policies and procedures, which have incorporated input from the community and immigration activists. Current state laws that regulate local law enforcement's ability to cooperate with immigration enforcement authorities have gone through tremendous discourse during the respective legislative process. There's no loophole when it comes to what is placed in statute. While there have been legislative efforts to amend and expand the reach of immigration laws, Governor Newsom vetoed the most recent proposal, indicating that he believes current law strikes the appropriate balance with public safety. As an independent elected official, I've set the policy for the Sheriff's Office and the Board of Supervisors. California law prohibits the Board of Supervisors from interfering with the independent constitution and statutorily designated investigative function as a sheriff. And it's clear that I have the sole and exclusive authority to operate the county's jails. State law allows for the Sheriff's Office to share release dates for individuals who are in sheriff's custody, and only if they have qualifying convictions for specific, serious, violent, or sex crimes. SB 54 gives the authority for law enforcement to cooperate with immigration authorities as prescribed. Many are referencing that because the board policy is in place that I have to follow it. However, unlike the local police department where the elected city council can set the policy for the chief of police, that council appoints an elected sheriff, answers to the voters, and sets policy for this office. The provision reference of policy doesn't impact the sheriff, however, applies to local police departments where their city governments establish their policies under SB 54 provisions.
Part 2 for this question, how many total sheriff staff are responsible for vetting individuals to assess if they are eligible to be transferred or not under SB 54?
We have 27 employees that work our jail population management unit, and that is one of their duties.
The next part reads, how much are their salaries? This discretionary use of county resources for intake, vetting, notification, and transfers is not supported by county policy L2, nor by community testimony at past Truth Act forums. The sheriff claims that she has not added staff to handle the increase in ICE requests for notification 2024, 1,236, and transfers from 25 in 2023 to 83 in 2025.
So I would invite this requester to go to the Sheriff's Office webpage and submit a Public Records Act request, since this request will require an extensive amount of information gathering.
Part 4, what other types of adjustments did the San Diego Sheriff's Office make to handle the additional cases?
There's been no additional adjustments.
Part 5, what other staff functions or funding for alternate community safety programs would be adopted if the sheriff would stop her discretionary collusion with ICE?
I'm not sure if this question is more appropriate for the board.
The last part of this question, as immigrants enter and exit San Diego Sheriff's Office custody and databases, what is the sheriff doing to prevent disparate treatment due to racial profiling or place of birth?
We work closely with our community partners and organizations on voter rights efforts and presentations, as well as educating on the hate crime laws.
Number 3,
Question 3 has 6 parts with a few subparts. Let's start with the first part. Can you walk us through where in the booking release process the judicial warrants come up, and how the Sheriff's Office responds to these within the SB 54 vetting process?
Federal immigration warrants are not subject to the provisions outlined in SB 54.
Once the Sheriff's Office receives a judicial warrant, how does the office verify that it's signed by a judge?
The warrant is received with a signature from the judge, and the sheriff's staff will visually inspect the warrant upon receipt and process the warrant.
How does the receipt of a judicial warrant for an individual in sheriff custody affect the sheriff's SB 54 vetting process for individuals?
Federal criminal and immigration warrants are not subject to the provisions outlined in SB 54, and once the warrant is received, the vetting process stops.
What are the forms and frequency of communication between ICE and sheriff staff about individual warrants?
The forms are federal judicial warrants, and we can only speak to the number of warrants that were received, 53 in 2025.
If a judicial warrant is received right before a person is about to be released, how does the department respond? For example, some individuals were slated to not be transferred to ICE custody, but we notice a judicial warrant is received the same day they're meant to be released.
Federal immigration warrants are not subject to the provisions outlined in SB 54, and they are processed upon receipt.
Part 2, when will the San Diego Sheriff's Office begin to post the monthly data about the number of interviews, notifications, and transfers on the sheriff's website?
So the monthly is not possible for us as far as our ability and data, the ability of our IT staff to pull that data on a monthly basis. But we are looking to begin issuing quarterly reports starting in August of 2026.
The next 2 subparts appear to be statements. I'll read them. Both supervisors and community advocates have repeatedly requested for years that the San Diego Sheriff's Office post data about the number of interviews, notifications, and transfers in the sheriff's website on a monthly basis. In fact, we made this request during last year's Truth Act form, and the sheriff shared she would look into it. The Sheriff's Office tracks this data on a monthly basis to prepare for annual reporting requirements under the Truth Act and SB 54, so there's no reason why this would be an extraneous task for the department. Part 3, what did the sheriff mean when she responded to the question submitted to the 2025 Truth Act with, quote, there are indications that this administration is also utilizing warrants in an unprecedented fashion, end quote. Also, why are we seeing a rapid increase in ICE using judicial warrants to facilitate transfers from the San Diego Sheriff's Office?
Thank you. This quote was based on public statements from the administration, and in May of 2025, the U.S. Attorney's Office initiated Operation Guardian Angel. It's a federal law enforcement initiative aimed at neutralizing California's sanctuary state policies. This initiative encouraged ICE officials to obtain federal judicial warrants for individuals in local California jails.
Part 4, how does the San Diego Sheriff's Office ensure that they are not transferring U.S. citizens in ICE custody? In 2025, there were 5 individuals who reported their place of birth as the United States of America. How and why the San Diego Sheriff's Office asked individuals who enter the San Diego Sheriff's Office custody to self-report their first history of birth, and citizenship during the booking process. How does this occur? Orally, in writing? How does an individual opt out? Can they refuse to answer? What are the consequences of refusing to answer? What % of individuals refuse to self-report? How do you use this information?
So that had a lot of parts. So the sheriff's office does not have the capability to access or look up an individual's immigration status. We do not have access to any databases that contain information about an individual's current immigration status. This is in accordance with our operational protocols and legal requirements. Additionally, JPMU is prohibited by law from communicating with immigration officials about an individual's immigration status. Our unit strictly adheres to these legal constraints to ensure compliance with all relevant regulations. Our operations rely heavily on the inquiries made by immigration officials. When immigration officials reach out to us, it's typically to notify us that they are frustrated in an individual's immigration status, and this usually implies that the individual may not be legally present in the country, and officials are seeking to determine if the incarcerated person qualifies under SB 54 guidelines. As far as how, and it is, as DSO asking individuals to enter into custody to self-report, there are countries that require mandatory notification if a citizen of their country is arrested in the United States. And if the self-reported place of birth is a mandatory notified country, the sheriff's staff will notify the embassy or the consulate. If it is a non-mandatory country, the incarcerated person will still be given the option to request their embassy or consulate be notified. And it occurs through the sheriff's international liaisons, and it's done via the phone or via email or text message. And the individual can opt out of self-reporting their place of birth, and we don't have a percentage of individuals who refuse to self-report this information that's not tracked, and we use the information to make required notifications to the respective embassy or consulate.
Part 5. Will the sheriff share redacted versions of the judicial warrants that were used to facilitate past transfers, 2024, 2025, 2026, and on a monthly basis going forward onto its public website for public review?
No, but there may be the availability of some of that information through our GovQA or Public Records Act platform.
In 2024, we saw an unprecedented number of federal judicial warrants for individuals in custody. Despite a request from community organizations, the sheriff declined to provide the specific violations or offenses for the individuals transferred under the offense code federal warrants. Next part, subpart of that reads, during 2025, we see the largest number yet of federal judicial warrants used by the San Diego Sheriff's Office to transfer individuals to ICE and DHS custody. Next subpart reads, in the interest of transparency, so we can better understand this disturbing trend, would the sheriff promptly provide complete information on specific violations or offenses for each individual transferred under the offense code of judicial warrants in 2024, 2025, 2026, and on a monthly basis going forward in 2026?
Yeah, as I stated in my last answer to the last question, no, but it might be available through our Public Records Act request, our GovQA website.
This last subpart is a statement. Our PRA requests have not received the priority responses that we would expect and that are required by law. We need this information promptly. The final part of this question, who other than the sheriff is responsible for safety and access to parking lots on county property?
The law enforcement agency or jurisdiction, so if it's downtown, it would be San Diego Police.
Subpart of that question reads, the sheriff denies responsibility for informal practices that circumvent SB 54, such as parking lot pickups, because she doesn't have custody over individuals once they are released from county jails, as per reply by sheriff to question 14 of the Truth Act Form 2025. Final question to this part reads, why does the sheriff continue to collude with ICE and deny her role in this devious practice, stripping immigrants of their safe and lawful return to the community?
So I think people misconstrue my authority. Once someone's been released from my custody and is in a public venue, I don't have authority over another law enforcement agency to engage in their unlawful.
Okay, number 13. I think it's the last question.
13 reads, with the L2 policy and the clear ordinance, the only legal way for the sheriff department to transfer an individual to ICE is when a valid judicial warrant is presented. Do you agree with the statement? If not, please point to a specific provision of the law and explain legal basis of transfers to ICE without a valid judicial warrant.
So SB 54 clearly gives me that authority under certain, circumstances involving certain criminal convictions under state law.
Are we done? 10 seconds, that's okay, I think that's all we can do. These questions, how many do we have left? Quite a number. Okay, so these will be sent to Sheriff Kelly Martinez. Sheriff Martinez, if you could provide a written response. And then-
We'll post it on our website along with the ones I answered tonight.
Okay, great, so we'll have, available for the public, written responses of not only what was answered here tonight, but also whatever we do not have to answer. So thank you very, very much, appreciate that.